helped co-found here, so I must add this to my bio, otherwise. No, seriously, I'm also one of the co-founding members of an organization called ALMA, which is the Association of the Promotion of IHL in Israel. So I wanted to also note that. And I want to thank very much NGO Monitor and Gerald for inviting me here to speak today, for organizing this event. I also want to congratulate NGO Monitor on expanding the scope of its work beyond the Israeli-Palestinian conflict. I think that's very important, and I think it bears very important lessons. And one of the lessons resonates clearly, I think, and it's something maybe to think about. In the book, one of the case studies was the DRC, the DR Congo mapping of the crimes report. And that was actually praised as one of the better examples, if not only for being modest about the goals that this report can achieve, and which I think is commendable, and other reports, perhaps in the methodology improvements, can maybe note the weaknesses, if anything. But I think what's interesting in a comparative perspective to the Israeli-Palestinian conflict is that that body was mandated by the same body that mandated the Goldstone report. And the Goldstone report is being declared politicized or biased inherently because it's mandated by a politicized body. So I just wanted to note that out. And so when you expand beyond the borders of our conflict and you see other things in other places, you might put things in context and perhaps be less generalizing in some of the statements. I wanted to refer to or add to some of the contemporary trends in international politics that Dr. Ben-Ari referred to in his previous talk, and add another one to the list of trends that he mentioned, and that one is the judicialization of international politics. And I come from the background of working for international criminal courts, and I have been part of this trend, and Professor Hampson has also referred to the role of international courts, both human rights courts and criminal tribunals, in establishing facts and legal findings in relation to IHL violations and international crimes. And I think that is one of the current trends that is also very important to highlight. That will be what I will focus on in the rest of my 10 or 15 minutes. And in that regard, I'd like to say that I think that NGOs play a very crucial role within that trend of judicialization of international politics, of international conflicts, of international law. And I think that in the spirit of Professor Hampson's British euphemisms, I'll add another, perhaps less sophisticated one from an English-based language called American. And they use the term, don't throw the baby with the water. And I think that exactly is in the same spirit. And if you do criticize, and there is room for criticizing, but I think that engaging in a discussion that is fruitful and that highlights weaknesses together with strengths will bring about an improvement of the standards and of the work of NGOs without throwing away the baby. And that is the very important work that they do carry out. And in the context of the judicialization of international politics and my work in the tribunals, I want to highlight several roles that the NGOs have vis-a-vis the international criminal tribunals. And after listing a number of roles, I will proceed to discuss those roles that have fact-finding functions or fact-finding aspects to them. And so the main roles that, and this is off the top of my head from my own experience. I didn't go and see what other academics, researchers. The book didn't really go into all of these roles since it focused on the fact-finding missions of NGOs. And so the main ones that, from my 5 years of work with the International Criminal Courts, I've noticed is the role of amicus curiae. So especially the Human Rights Watch has been very active as amicus curiae before the international ad hoc tribunals. Another role is outreach and sort of advocacy with relation to the courts. And again, there's NGOs beyond human rights NGOs that do this kind of advocacy and outreach work, but also the NGOs, the human rights NGOs do this as well. And when I say outreach, it's not only telling affected societies about the work of the court, but it's also convincing witnesses and victims to come before the courts and persuading them that it's important. And I think this is a very critical role that they carried out. Another role is monitoring. You have some of the human rights NGOs are monitoring court proceedings to check on them, to publish their adherence to due process and to fairness standards. And that is also with relation to national courts that enforce international norms, which is a very important function. And the one last function, which has two sub-elements, is evidence. They provide evidence to the courts. And that has two, as I said, subcategories. One type of evidence they provide is exhibits. So these same reports that we're discussing here, the fact-finding so-called reports, and by the way, I'm not sure that all these NGOs always refer to their own reports as fact-finding reports, even though they find facts, all right? But a lot of these reports end up as exhibits in the courts. And it was, Professor Alan Stevens discussed the idea of evidence and admissibility, whether we should exclude the evidence or not. Well, the approach of the criminal courts, the international criminal courts at least, is to include all the evidence and then assess its credibility at the end of the process. And that could result in giving certain evidence zero weight, of course. But everything is admissible initially. And so are all these reports by a lot of these NGOs. So they're admitted as exhibits, and they're no less or no more reliable a priori than any other journal, book, media report, whatever other exhibits are entered into the evidence. And the other form of evidence is the other second subcategory of this category of evidence is testimony. Often those who wrote those reports for the NGOs are called in as witnesses, sometimes even expert witnesses, depending on their own credentials. And we've had at the ICDR the recently deceased Alison Deforge, which was in 11, 12, or even 13 trials, a witness testifying as an expert witness on Rwanda. And she, since the early 90s, was one of the senior investigators in the Africa department, later to be head of that department in Human Rights Watch. Her book and a lot of the reports that she authored were also entered as exhibits. But her famous book, Leave None to Tell the Story, from 1999, had outlined a lot of the different violations and crimes that occurred during the genocide in Rwanda in 1994, and also crimes by then non-state actors that did not amount to crimes of genocide, but were still crimes in her analysis. And I'll get back to the legal analysis part of the reports later. But the testimony element of the testimony function of the authors of human rights NGO reports, it has been very critical for the work of other international criminal tribunals as well, not only the ICTR, and the other one which I worked at was the Special Court for Sierra Leone. And again, a Human Rights Watch reporter, investigator by the name of Corinne Dufka. Corinne Dufka has been hired eventually by the Special Court for Sierra Leone as an investigator after having worked for a number of years for Human Rights Watch as an investigator in Sierra Leone. A lot of her work has also had the function of alarm that Professor Hampson has referred to beforehand, because although they were detailed reports, they had provided this alarm and the awareness, it had brought to the awareness of the international community some of the atrocities that were committed in Sierra Leone. And the war in Sierra Leone started in 1992, but not until 1999 did atrocities start entering the consciousness of the international community through, not CNN, they were not the first ones there, but exactly these reports of Human Rights Watch. And it's this one report that I'm thinking about that she wrote, which was called Getting Away with Murder, Mutilation, and Rape from June 1999, which documented the atrocities in Freetown in January 1999. Now, The Freetown invasion in 1999 by the RUF and AFRC, two non-state actors, by the way, who had committed crimes that were documented by Human Rights Watch, those atrocities were the last straw for the UN and for the international community that had made them decided to create the Special Court for Sierra Leone. So there was a very important role to the work of NGOs. And Corinne has actually went to the field during the time of the atrocities and taken hundreds of statements from victims and eyewitnesses. And also she got the perspectives of government authorities, etc. But these hundreds of statements had provided the information for her report and had alarmed the world and had ended up with a Special Court for Sierra Leone. As I said, she later on started working for the Special Court as an investigator. She's now back with Human Rights Watch. But this kind of work is not done by many actors. And again, for that, I think we have to value the work of human rights NGOs. They're a bunch of crazy freaks sometimes. They're like war correspondents. They're even worse. I had a conversation yesterday with Int'l, the war correspondent from our country, who said that it's sometimes him and Human Rights Watch investigators in the front line. And there's not going to be any international court investigator, definitely not a lot of other private actor investigators in that area. And so I think for that they should be commended. That also comes with all the limitations, some of which Professor Hampson has highlighted: the security challenges, the access challenges, the cooperation challenges from different actors, the trauma, and the trauma itself, not just the re-traumatization while taking the testimony, but the trauma itself of the events does hamper some of the evidence, and that's an issue that the tribunals have dealt with as well. The memory of the events, even at a short time after the events, is distorted by the trauma, and that later cannot be said to weaken the report because there's some diversions between the real forensic truth and the accounts of that truth. And that is an important point to remember, that, and that brings me to my concluding remarks. I can't see the time, I think it's locked. But that brings me to the concluding remarks. And I refer again to some of the things that were said in the opening remarks by Alan Stephen. And he spoke about true or not true facts. And I think not many people, and even I don't think your book talks about the facts as lies as such, but more about selective truths, right? So we're not challenging the truthfulness of the facts, but rather the compilation and sort of the selectiveness of them that could lead one to conclude certain conclusions, right? And I think some of the selectiveness is again due to the impediments on the ground. They're not necessarily because of some predetermined political bias. And I think the comparative aspect of your work will let you perhaps see that in a more clear way. It's more difficult when you're taking sides in a specific conflict that you're emotional about. And I think that these challenges do explain a lot of the selectivity. And when you look at the NGOs as part of the judicialization, part of the judicial efforts to coming to the facts, to the full extent of the facts, and then perhaps drawing the legal conclusions, then you could say that the facts should be valued on their face value. The facts can be added on to with other facts. So this is another useful conversation. If the fog of war then disseminates that there's a possibility to go back to have access or to have cooperation from certain elements that you couldn't get cooperation from later, you bring that in, you have a fuller picture later on. I'm aware of the fact that the timing of certain reports has public image impacts. But the greater picture that I'm looking at, the international criminal courts and other judicial bodies that are very much evolving, and I think the, time's up. And I think the future will take us forward in that direction. We'll see that in the perspective of time, the puzzle, I mean, these are very important pictures of the puzzle. And I think a lot of the voices of victims and a lot of the voices that do come out in these reports are important for the judicial process, are important even, I want to use a term that was used before, the democratic deficit. They're talking about democratic deficits of international courts as well. Because you have a prosecution and a defense. The ICC now also has a victim participation element. But in the other courts, it's those amicus curiae of the NGOs that brought the public opinion or the victims' perspectives and interests. And so that sort of mitigated the democratic deficit, so-called, of the international courts. And so I want to just second what was said before about the engagement and the very important constructive criticism kind of conversation that could and should be going on. Thank you very much.